Unfortunately, I'm here. And I'm glad to actually be part of this, be in Denver. General Denver is a state, a city where I was born.
Yes.
Don't know Denver that well. We left when I was very young to move back to Haiti, where my parents are from, and lived there for a few years before coming back to the United States. But I am very fascinated by the Lawfare project. And it is something that came to my attention years ago when I met Brooke and we began to discuss these issues. These are very important issues that we need to contemplate and address as we look forward in time, and look forward as to what the state of the world will be and should be. Half of my professional career, probably more than half by now, has been devoted to the issue of international law. I started off as a prosecutor, a deputy district attorney, then an assistant United States attorney. But then I moved into the international space. I moved into that space to address the genocide that occurred in Rwanda. Now, what's interesting about this, it was at a time where the international law, or modern international application of international law, began to develop. It was the first time that we were creating international tribunals for Rwanda and Yugoslavia. It was the first time that international law, the Genocide Convention, crimes against humanity, war crimes, was really being applied since World War II. And at that time, the events, they started for a very noble purpose. And the purpose was to bring justice for these egregious crimes, these mass crimes where there was no justice for the voiceless. But as time went on, we began to see that the process, the system, began to be hijacked, as Brooke just said, for political means. The issues began to lose their way. People began to see that this was a vehicle for them to achieve their gains, their political gains, rather than helping the victims, the survivors. But I want to make one point before as we move on, and something that's very important to remember. International law is important. International law is needed. There is a right way to use it, and there is a wrong way to use it. And then to illustrate this point, I want to tell a little bit of a story. And it's the story of a woman that we called Witness JJ. Witness JJ is a Tutsi Rwandan woman. 18 years ago in April, in the beginning of April, she was living her life with her family, a family of approximately 7 or 8 people. Then on April 6th, in Rwanda, the plane of the president was shot down, the Hutu president. That ignited what we now know as the genocide. But immediately on April 6th, April 7th, April 8th, we began to see the militia, the Hutu militia, began to go out in the streets to set up roadblocks. They began to go after the minority Tutsis that were 14% of the population. They would stop people by the roadside and say, "Let me see your identity card. If you're a Hutu, you're free to pass. If you were a Tutsi, you were pulled off to the side. You were pulled off to the side and executed by a club or a machete." Now, during that time, Witness JJ was in her house, and the militia came. She saw the militia grab her father, grab her brothers, and execute them in horrific fashion. And then when she left the house with her sister, her mother said, "Run." She and her sister went to the bush and started to run, and they were captured by militia. Now, I'm not going to go into too much detail, but your imagination will take you where it may. She and her sister were violated at that time by 3 different assailants in the most horrific manner. She then decided to run to the city hall, where she thought it was a place where she could seek sanctuary, be protected by the mayor that to whom she would go hat in hand in the past with great deference, to say, "Mr. Mayor, I have a problem with my neighbor. Mr. Mayor, I need help with putting my child in school or my brother to school." On her way to the city hall, she was repeatedly violated again and again and again. Now, her story is not uncommon. This happened to a lot of other women throughout Rwanda. So by the time the end of April rolled around, the Hutu militia had killed all the moderate Hutus that would have actually put an end to the genocide. They killed the Tutsi leaders who could have ascended into power and taken over. They then began to kill all the intellectuals, the people who could assume leadership positions. They then went after all the fighting age men and boys, people who could be the strength, the pillar of the community, so that it would move on. And then they targeted what was left, the elderly, the women, and the children. Now, when witness JJ arrived to the city hall, she learned that the mayor, the person that she thought would protect her, was an assailant. She learned that he was administering the genocide. And she also learned that this sanctuary was not a sanctuary. It became a detention facility. It became a rape camp where she and countless of other women were violated again and again and again. By the time the genocide in Rwanda finished, in a 100-day period, 1 million people died. Do the math. 1 million people in 100 days. 10,000 people a day. And the international community stood by and watched. Let it happen. At that time, there were UN peacekeepers in there, about 5,000 UN peacekeepers. And instead of protecting the population, they left. They left the country, leaving a core group of only 500 people who would protect the barracks. Also, by the end of the 100-day period, after the Tutsi military came down from Uganda and seized control of the country, we saw an exodus of about 2 million people into Zaire, which is now the Democratic Republic of the Congo. So by the fall of 1994, a country that once had a population of 8 million people, 1 million were dead, 2 million were gone, that fled the country. So when I first arrived in 1995, what we found was a country that was destroyed. Not only destroyed from a physical perspective, the infrastructure, the buildings, the roads, no electricity, no running water, but destroyed from a human capital perspective. There were no lawyers, no judges, no doctors, nothing there to help the people. And it was in this instance that, as part of the rebuilding effort, the international community rightly looked to international law to try to redress these horrific events. We needed to bring justice, not only to a people, but to a region for what happened there. It was important to send a message that genocide, real genocide, will not be tolerated. It was also important to put in an infrastructure where one did not exist, because there was no way that in Rwanda, or in the region for that matter, they could actually bring justice, because there were no lawyers, because there were no judges, because there were no investigators, all the things that we take for granted here. When I arrived, we began to build the entire apparatus for the prosecution of the genocide in Rwanda. Our sister tribunal was also unfolding in The Hague to deal with the former Yugoslavia. That is when I met witness JJ. It took some time for her to begin to talk to me, to tell me about what happened to her. As you can imagine, these are not events that one wants to share. It also took some time for her to actually find the trust, the confidence in the United Nations to address these abuses. Why should she trust the United Nations? We left them in the past. We did not answer their call. But after 8 months of working with her, showing her, explaining to her the process, she began to believe. She had no idea what international law was, what the purpose of international law should be. It was a process that was completely foreign to her, foreign in application and foreign in reality, because the principles, the people involved were from all over the world. So I finally persuaded her and some of her friends to become part of our core witness team to prosecute the first case, as Brooke said, of genocide in the history of the world. We ended up setting up our courthouse in Arusha, Tanzania, next door to Rwanda. We did it for security reasons. And as we moved through 1996, we did our investigations, and we built to 1997 when we were about to start the case. We all flew over to Tanzania and began to marshal the evidence of the genocide. We began to actually develop the theory as well that rape was a form of genocide. Now you need to understand, at that time, rape had never been prosecuted before in a time of conflict. Never. Not as a crime against humanity, not as a war crime, not as a case of genocide. So we began to develop the principle, to make the argument that this crime should be put on equal footing with all other crimes on the international stage. Now, as we moved through the process, it became now the fall. It was a very lengthy trial. It was the fall of 1997. I brought witness JJ and the other witnesses, the women who had been violated, to our safe house in Tanzania. And witness JJ, it was the day before she was to testify. She came up to me and said, "Mr. Prosecutor, I can't do this. I just can't speak on these issues. You need to understand, at that time in Rwanda, the issues were taboo. Can you imagine that if someone found out that you were a rape victim, people wouldn't talk to her. She would be outcast. She would never remarry. She would never have a partner again." And she says, "You're asking me to go before this international tribunal, something I know nothing about, and tell my story not only to these judges from Senegal, Sweden, South Africa, but also to the world, because BBC, CNN were there filming." So I sat witness JJ down and began to talk to her, and I said, "I absolutely understand. I can't make you do this, but let me tell you a story." And I began to tell her a story about what the women in Bosnia were going through and had gone through, with the rape camps that were there. We began to talk about other conflicts where women were abused. We talked about World War II in the Far East and what happened there. And I told her, I said, none of those victims had ever had their day in court, had the opportunity to point the finger of accusation. Many died without a voice. So I said, you have an opportunity to make a difference, an opportunity to speak for all those that came before you. The most amazing thing happened at that time. Before her head was hanging low, and as I began to explain to her what I just described, you could see her head lift. And she finally said, "Okay, I will do this." So the next day we went into the courthouse and she began her testimony very quietly. But as the day went on, there was an 8-hour examination between direct and cross-examination. Her voice became stronger. She began to speak loudly and point to the accused and say, "This is what you did to me. This is not acceptable. Never again. This should not happen." So by the time she finished testifying, we went back to the safe house. The other women who were also terrified and afraid saw how now witness JJ had literally a bounce in her step and was motivated and excited. And they all rushed to me and said, "I want to be next. I want to be next." It was the rule of law in full application. And that made me realize the rule of law is not about me. It's not about us, in a sense, those who practice it every day. It's about what it means to the victims, the people, to the society. It's about instilling in the society the fabric of democracy that allows it to grow and provides barriers to impunity. We ended up winning that case. We won, as Brooke said, the first case of genocide in the history of the world. And for the first time, we put rape and sexual violence on equal footing. So today, the international law aspect of that, based on witness JJ's courage, was that there is a precedent that can be used to protect populations around the world. Now, since those days in Rwanda, I've watched the development in this space. In fact, I've been part of the development in this space. I was in part of the negotiations for the International Criminal Court. I was involved, responsible for setting up a special court in Sierra Leone, dealing with Cambodia, dealing with the Balkans. And I witnessed firsthand how this noble cause, this noble issue, began to be pulled and tugged, manipulated, and hijacked by persons who have a political purpose. They were not concerned about the witness JJs of the world. They were concerned about their agenda. We began to see this in the negotiations for the International Criminal Court. We began to see it as people started to espouse this principle of universal jurisdiction. Universal jurisdiction is any country can prosecute anyone for just about any crime, international crime, anywhere in the world, no matter where it existed or took place. Meaning, you could be, as we know, a judge in Spain wanting to prosecute the United States for acts in Afghanistan, or prosecute Pinochet, remember that case, for acts in Chile, when there is no nexus, no connection to Spain. And as an important footnote, recently that judge, Judge Garzon, has been now indicted for corruption. This person who used to use this principle of universal jurisdiction to go after persons. This began to grow. We saw universal jurisdiction applied in Belgium, well, during the Iraq conflict, where there were indictments against our Don Rumsfeld, the vice president, the president. People began to use this for political reasons. It wasn't for the victims. It was to serve their agenda. I also remember when we were getting ready, when we were in Afghanistan, I was in office and we were going to Afghanistan, going after Al-Qaeda. At one time, Mary Robinson, the then High Commissioner for Human Rights, effectively said that the United States needs to be prosecuted for war crimes, for crimes against humanity. And this was her theory. We had closed a passage in Afghanistan that was used to transport food, but it was closed for security and military purposes because we were bombing in that area, and we didn't want convoys to go through. So it was closed to just go after the target. So her argument was, well, you closed it, food is not going through, that's a war crime. When in fact the purpose was to protect the population. So it was part of an agenda to go after the United States. Now, throughout the 2000s, the early part of last decade, we saw this grow and grow and grow, as Brooke described. We are now to the point where you're seeing issues such as the Goldstein report, where the Human Rights Council launches an investigation for the sole purpose of going after Israel. It wasn't about the substance. Recently, I defended a case in Oklahoma, and this was a case against the government of Rwanda, the president of Rwanda, where the former Hutus, the people who were kicked out of the country in 1994, filed a lawsuit in the United States against the president of Rwanda, and they were rewriting the history of the genocide. In the complaint itself, it basically diminished what happened to the Tutsis, began to label it as, they say, if anything, it was a double genocide, and then they would say, and since then, the government has been committing genocide all the way through to today. And as Brooke said, what we've been seeing is that the term or terms have been politicized and used for political purposes. People begin to throw it around. Now we have a decision, a responsibility as we sit here today. And that is, we need to find a way to take back the definitions, take back the process, and revert them to the true intentions and the true meaning. We should be able to and want to prosecute people for genocide, for crimes against humanity, for war crimes. But in order for it to be true and effective, it can't be politicized, and it can't be part of this lawfare, a means to destabilize democratic governments. I returned to Rwanda in 2004. At that time, I was part of, I led a presidential delegation to commemorate the 10-year anniversary of the genocide. And I remember then we were looking at all these issues, what should be the way forward. And we did a couple of things as part of that exercise. One, we began to see the way the law was going, and we decided we have to try to pull it back to its rightful meaning. We also began to look at the idea of domestic application. Rather than having these processes that are just based in these international forums, where a victim, let's say in Sri Lanka, has no idea that justice is being administered on his or her behalf 10,000 miles away in The Hague. What we need to be doing is working with these societies to build the rule of law domestically. Our job should be to help them. If justice is about the victims, helping the victims, then we need to make the rule of law as local as possible, rather than 10,000 miles away in The Hague. That's the only way that democracies will grow. We need to establish ownership by these societies and responsibility for the application of these laws. An example that I always give when I talk about these issues is our election in 2000. And people say, well, what does this have to do with anything? And here's what it means. In 2000, the office of the President of the United States, the most powerful position in the world, was decided in a court of law, or settled in a court of law. And not a single person was jailed, killed, or injured. And the reason being is because we accepted the result. Half the population may not have been happy, but they accepted the result. And the only way you get to that point is when you have a true application of the law with integrity within its meaning. When you have ownership by the people. The moment the law becomes politicized, then you lose what we had in 2000. People will reject the result. They will reject it and say it was a political decision, and chaos will resume. So for all those people that want to use this lawfare as an approach, they need to understand that while it may serve their immediate purpose, it will backfire. It will backfire. So we need to do our part to maintain the integrity of the law. We need to do our part to reject these efforts to politicize the law. Because without the rule of law, in my view, there is no democracy. Forget about elections, forget about everything else. It's fundamental as the rule of law. As part of this visit in 2004, I asked my ambassador in Rwanda at the time, I said, I want to go back and find witness JJ. You know, I hadn't seen her in almost 10 years. I wanted to know, how was she doing? So they set up a meeting for me to meet her and a few of the other women there. It was down deep into Rwanda, about an hour or so drive. I remember driving down, and for those of you who have never been to Rwanda, it's a very beautiful country, rolling hills, lush green countryside. You couldn't imagine that a genocide took place there. As I was driving to our meeting point, which was now the new city hall, I remember we're driving up a hill and I start seeing people in brightly colored outfits walking up toward the building, which was at the top of the hill. As we move closer, you can see that these people walking in brightly colored outfits were women in their finest dress, as you've seen before on TV, or if you've been to Africa, the bright colored dress and headgear. As we pull up into the city hall, which is called the Bureau Communal, and I drive in, I realize that these women walking up the hill were walking there to meet with me. And then I got out of the car and I realized there was about 800 women in this small little government building. And then when I walked in, they began to sing, they began to dance and clap. And I sat down after it was over, after they finished their singing and dancing. The leader and witness JJ came by and they said, as part of the public presentation, thank you. Thank you for what you did for us back in 1994. Thank you for bringing justice. Thank you for recognizing what happened to us as women. They also said thank you for coming back, for remembering us. Now we need to remember. What happened in 1994 to us may have been a moment in time and an event, but for these people, they're still living in the aftermath. Unfortunately, witness JJ was HIV positive. And a child that she had, as with many other women there from the genocide, also HIV positive. She lost her land that was owned by her family. No employment. Now, we still have a responsibility to people like JJ, to people around the world that are victims of atrocities. And we need to remember that not only these were not events that just happened in a moment in time, but there's continuing suffering. We need to remember that to honor what happened there, what happened during World War II or anywhere else, that we need to uphold the integrity of the law. If we let it be hijacked, we let it be taken away, we let it be diminished, then all our efforts have been wasted. So I applaud all of you for being here today and being interested in this project, because what Brooke and her team and everyone is doing is critically important. If we don't draw the line now, then who will? Thank you for your time.
So, thank you so much for joining us today, Ambassador Prosper. We wanted to give you the first ever John Locke Award for preserving freedom and the rule of law. And it's presented for your dedication to the just implementation of the law and your valiant efforts to safeguard the sanctity of human life. And we're terribly honored to give this to you. Thank you so much.
Thank you.
So, opening up to Q&A. Q&A, but I just want to say before we do that, what Ambassador Prosper did is enormous. He litigated into the Genocide Convention mass rape as a crime that can be prosecuted. And we owe him a lot. But the truth is, there's a shortage of lawyers who are willing to do the same. And methods of asymmetric warfare that are being used on the battlefield are developing at a much faster pace than the laws of armed conflict are. And this has led to all-out misinterpretations of the law, failure to apply the law, and to confusion. And we're at a point where the Attorney General, Holder, is calling to read Miranda rights to terrorists captured on the battlefield. And Kenny Roth, the head of Human Rights Watch, calls the shooting and killing of Osama bin Laden a violation of international law. Now, I don't know what Geneva Convention they're reading, but the oldest principle of the rule of law in armed conflict is you can shoot and kill an enemy combatant on the battlefield, and you can hold an enemy combatant for the duration of hostilities. So what we've done at the Lawfare project is set up a mechanism by which we can monitor and facilitate a response to the abuse of the law as a weapon of war, and to encourage attorneys to stand guard against this manipulation. So we've just launched ANGEL, Attorneys and Academics for International and National Justice Under Law, to help the victims of lawfare and to follow in the footsteps of people like Ambassador Pierre Prosper. So with that, we can open it up to a little bit of questions.
Great. Actually, one quick comment. So, as you shape your questions, one of the things I did not discuss, because it's a whole other set of remarks, but as part of my tenure as ambassador, I was responsible for dealing with the whole terrorism detainee issue. Right after 9/11, I was put in charge of answering the question, what are we going to do with Al-Qaeda, particularly once we capture them. So I was responsible, involved with the whole setting up of Guantanamo and everything that followed suit. So if you have questions in that area, we can discuss this as well. Thank you.
As I've watched some of these suits against journalists and others, while they're distracting and can have some defense expense in the United States, they don't go anywhere. Some of them in Europe tend to last a little longer, and I had a real wake-up call last October. I went to Russia to talk about hate speech versus hate crime, and was shocked to find how many European countries have hate speech laws where you can be convicted of hate speech separate and apart from any hate crime. And isn't that kind of a fundamental thing we ought to be talking about, that Western democracies really shouldn't even tolerate hate speech as a crime without hate crime occurring, action occurring?
Yeah. Well, that's and Brooke, you may have some thoughts on this too, but that's a very, very important question. One of the things that I did, and my term actually just finished this month, I was part of, I was a vice chairman of the UN Committee on the Elimination of All Forms of Discrimination, Racial Discrimination. We would meet several times a year in Geneva. One of the issues that we would deal with is this exact point, where the European mentality, they don't have the, they don't recognize the principles of free speech as we do. And for them, they are pushing every European country as part of the EU and elsewhere to basically outlaw speech. And we would have this debate in Geneva about this, where we would say, look, it's offensive. Sure, it's offensive, but was there a crime? So if you say, and this issue with the cartoons, of the Danish cartoons, we actually had to deal with this. And the committee wanted to take a position and effectively sanction the Danish government for the cartoons and not being aggressive enough in its pursuit of a prosecution. And so we would go back and forth and debate this particular point, and I would always err on the side of what I believed in was free speech. And I said, look, I find them offensive, but we can't regulate that. But it's a big debate there. Another issue, which I'm going to digress for a moment, is our committee we're looking at forms of what we call racial discrimination, which is very broad. It's actually color, race, national origin or whatever it may be, things that you're born into. There's another movement that is out there that they're trying to put religion into these categories and have various laws that will make it a crime to discriminate or say offensive language, whatever it is, against religions. Here too in the committee, what I argued, I said, look, this is impossible to regulate, first of all, because religion is fluid. It's not, I mean, while maybe the core of your belief, it's not the core of who you are. And what I mean by that is, you could be a Catholic today and a Muslim tomorrow, as opposed to if your ethnicity does not change, it's with you for the rest of your life. And those are the core things that you protect when you're protecting against discrimination. So that's an issue that continues to be out there, and it's actually, as Brooke said, gaining momentum.
Just to add, think about it for a second. We have Western countries advocating for the resurgence of blasphemy laws. Okay, we're going back a couple hundred years. Whatever happened to John Stuart Mill, John Locke? The American concept of free speech is a universal concept of free speech. And what's happened in Europe is a lot of the blasphemy laws that have been dormant on the books for about 100 years are now being resurrected by Islamist parties, and they're using that to prosecute tenets of Sharia law. And under Sharia law, it is a crime to commit blasphemy, to say anything offensive. And the irony, I mean, I always have to mention it, it was the Jews after the Holocaust that advocated for hate speech laws, because they wanted to outlaw any Holocaust denial, and they wanted to outlaw the anti-Semitic cartoons. But it's a great lesson in what, John Locke said. It's a slippery slope. When you outlaw cartoons that are offensive to Jews, ultimately it's going to go towards anything that's offensive to any type of religion. And just recently, an Austrian woman, Elisabeth Sabadich-Wolf, was convicted in Austria for the crime of blasphemizing Islam by delivering a lecture to a classroom about the history of political Islam. So it's a massive problem.
I've got a question for both. We're starting to see a little bit in the judicial system in our country, the Sharia law come in. It's starting to creep in. I'd like to get your thoughts on, you mentioned Oklahoma. Oklahoma tried to get legislation against Sharia law, and it was shot down by the administration. Where do you see this headed in the future for Sharia law, specifically the judicial system in this nation?
Great. Well, thank you. My thoughts are a little more, global on this issue. And I think Sharia law, that issue falls within it. There continues to be discussions here, and particularly in Europe, regarding being a multi-ethnic society versus being a multicultural society. Europeans and the Canadians, for that matter, keep saying, well, we're multicultural. And what that means is if you're becoming a multicultural society, then your norms, your laws, whatever else, have to be multicultural, which means you get into some of these Sharia law issues, you get into some of the, whatever other cultural issues exist. And then you find, actually, when they try to say we're multicultural, what they actually do is they create almost a deeper divide among the various groups, because you have one group in a society that's exercising Sharia law and doing whatever they may be doing, other groups doing something different, and it goes on, and you ultimately never see the societies come together and have a common identity or a common bond. Now, what I always advocate, and I advocated this in my role in Geneva, is we need to be encouraging multi-ethnic, which is you recognize that people come from different backgrounds and have differences, and of course what you do in your home is what you do in your home, but we need to have a common bond, a common unity, and effectively a common culture for the societies to advance. And in the United States, my view is we know what our historical legal mechanism and system has been, and we need to honor that. If you come to the United States you come here knowing what we're all about. You know, of course we're a flexible society, we grow and we change, but that doesn't mean you change your core principles and beliefs.
Just, really quickly, the problem with anti-Sharia legislation is that it targets a segment of this population, and that's unconstitutional. I do not support a piece of legislation that says, we don't want Muslim law. What I want is a piece of legislation that says the Constitution is the supreme law of this land, and no foreign law that conflicts with our principles can be applied. And I think it's really terrible, a terrible reflection of where we're at right now, that we have to have a piece of legislation that reasserts the Constitution as the supreme law of the land. I was born in Canada, and I came to the United States because I have a deep respect for the history of the judicial system here and for the Constitution and the rights enshrined therein. And I chose to practice here because in Canada, we have no right to free speech. We have no right to property. Okay, there's no eminent domain. The Canadian government can come and take away my land and doesn't owe me a cent for it. And yet, I'm practicing here and I get calls almost every week, people saying, I'm writing a blog, is blasphemy a crime here? Or I'm writing an article, what are my rights under the First Amendment? So we have a serious problem with education in this country, that people aren't being educated in their schools as to what the rights are in the Constitution. And that's why I wrote that book, Lawfare, the War Against Free Speech. It's a very simple primer on what the First Amendment is, with case examples and what is protected speech, what is not protected speech, and what you need to do to protect yourself if one day you become a victim of a lawfare suit.
If anybody watched the Grammy Awards, they would know that blasphemy is not a crime.
Yeah.
With regard to the lawsuits that you brought up, it seems like the way you described it, they're being brought up all over the world, very concerted effort to stifle free speech from anyone who is trying to make comments regarding radical Islam. And as Attorney General Suthers said, essentially these aren't successful, as you said, they're being dismissed before the discovery stage. Do you think that there's a primary purpose beyond winning a civil lawsuit behind the lawsuits? And secondly, have you been able to identify whether or not there's an organized group or groups or persons behind doing these lawsuits throughout the world, that would indicate possibly a conspiracy to achieve that, whatever greater purpose they're trying to achieve? Or are these loosely associated parties that are bringing these lawsuits?
Well, in Europe, they are successful. I just mentioned this woman in Austria. Here, they are not successful because we have the First Amendment. But in Europe, many newspaper and authors have issued public apologies because they don't want to go to jail. Even though Geert Wilders was acquitted, I think after about 3.5 years of the lawsuit against him, now they're taking the Netherlands to the European Court of Justice. So they are successful, and I'd say the main parties on the international level is the Organization of Islamic Cooperation. And here in the United States, it's CAIR, the Council on American Islamic Relations, NIAC, the National Iranian American Council. And then there's, of course, various Saudis who are hiring law firms all over the world. I mentioned the Saudi law firm that went after the Wall Street Journal in Europe. But just recently in Canada, there's a debate over ethical oil there. And so a not-for-profit directed and broadcasted a public service announcement saying, buy Canadian oil, we want ethical oil. And the Saudis hired a law firm and sued them for defamation, and it was completely meritless. And so the point, like I said, is to intimidate anyone who is talking critically about these issues, and with intimidation impose this chilling effect so that we can't discuss it and understand it and combat it.
Let me just add one quick point. And the other purpose is, in my view, many of these suits, it's not about winning or losing. It's a political statement they make by simply having a complaint out there or an indictment out there. And that's the value that they get, and the end result is effectively meaningless. They'll use that moment as a means to try to, as a catalyst for action against that particular government.
You mentioned Attorney General Holder. Have you been able to discern either in their words or their deeds the position of this administration or this State Department on this kind of activity, internationally or even locally? I know Attorney General Holder views, but do you think he's representative of any particular? I don't want to be too political about the question, but do you think do you detect a position that they have on this reality?
Well, I'll take a stab at that question, and I know you have views. I think just quickly, I've watched this administration from both, from the days of the campaign to actually when they took over, and I remember what they were saying about us, in the Bush administration when we were engaged in various activities, and as Brooke said, the president said, "I'm closing Guantanamo on day one," and all these statements and rhetoric. But I think one thing that has happened over the last now 4 years is the reality is catching up to them, and they're recognizing that these issues are more complicated than it was from the view of Yale or Harvard or wherever they were. And they're realizing that there are real threats out there that you have to contend with. There are real agendas. Now, they may not be as vocal as they were when I was in government, but underneath it, behind the scenes, they're still there. And in my view, there is still a concerted group of people, a concerted effort to diminish the power and authority of the United States by people out there. They may not be saying it as loudly as they were before, but it's still there. We're naive to think that everything is fine and is going to be fine.
I just think that you gotta judge someone by their actions. I'll just repeat what I said. DOD has just advertised the fact that they redacted the word Muslim and Islam and Islam is terrorism from all counterterrorism training manuals. Clinton had a press conference with the head of the OIC claiming that she's now going to work to implement Human Rights Council Resolution 1618. What does that tell you?
What is your position about the United States not recognizing the authority of the International Court in The Hague?
Yeah. Well, I have serious views on this because as I said, I was involved. And if you think about it now, we've got three administrations. You have Clinton, Bush, and Obama. Obama's been silent on it, but silence is telling. I'm very comfortable with our position, and I'll tell you why. The issue with the International Criminal Court is it's a noble idea, based on the conversation we had earlier. But the problem with the court is that it's an unchecked entity, meaning that there is no supervisory body. It doesn't answer to the Security Council. It doesn't answer to the NATO, EU, or any regional forum. So what you have at the end of the day is you have a prosecutor that could actually wake up in the morning, read the newspaper, and decide that he or she is going to launch an investigation against just about any country in the world. So that power is invested in that individual, and it is unchecked. And they'll have a huge press conference and say, we're going to go investigate Israel, we're going to investigate the United States, whatever country it may be. Now, people may say, well, that's fine, we can trust the prosecutor. Well, we know that individuals can have a political agenda. And what we were concerned with is that they'll gravitate to what is, the sexy, if you will, rather than what is really based on fact and law, and try to get the attention. The other problem with it is these individuals will immerse themselves into a conflict at the most inopportune or inappropriate time. With the International Criminal Court, we have to remember it's dealing with genocide, crimes against humanity, war crimes, but we're talking about serious breaches of international peace and security. And it's not the time. There are times where the peace talks are very delicate. You don't need a prosecutor racing there and making a public announcement to try to put the spotlight on that. I'll give you a quick example. When we were in, I think it was about 2004, we were going after Charles Taylor in Liberia. for what was happening in Liberia and Sierra Leone. And we were working very hard to get him out of office. And we, the United States, with the Western African, Nigeria, and others. The Special Court of Sierra Leone informed me that they had an indictment against him for all the acts he did or was responsible for in Sierra Leone. And I was fine with that. The guy needed to be indicted. But what I asked the prosecutor, I said, look, just keep it under seal. We're in serious talks right now. We're about this close to having him voluntarily step down. Once he steps down, you can do whatever you want. So we set up a peace conference of talks in Lome, in West Africa. And on the day of the talk, the prosecutor decided to become relevant and publicly release the indictment. Charles Taylor immediately got on a plane, went back to Liberia, and the conflict that you all remember now started. And here's the most important part. At that time, Charles Taylor, when people were dying in the streets and we put an aircraft carrier off the coast in West Africa, Charles Taylor made a statement which is very telling and goes to this concern. He said, would you really burn the whole house down? Would you really let the whole house burn down just to kill a rat? Meaning, he's going to basically rape, pillage, and kill the country before he is caught or killed. Fortunately, we were able to resolve that, but this is the problem that we need to understand. That's one of the concerns that we have with the court.
I just think that, as Ambassador Prosper said, there's no due process in international law. When the International Court of Justice can release an advisory opinion on the Israeli security fence and refuse testimony from Israeli, Arab, and Christian victims of terrorism, and refuse to enter into evidence the fact that the fence has led to a reduction in the loss of human lives, there is no due process. When Libya can sit on the Human Rights Council, there's no due process. When the Commission on the Status of Women is headed by Saudi Arabia, there's no due process at the United Nations. So before, and I agree with Ambassador Prosper, international law, there's a sanctity to it. There's a sanctity to humanitarian law, which is laws of armed conflict, and we want to uphold it. But before we submit to the jurisdiction of these types of courts, surely we must ensure that there will be checks and balances to it.
I'm a little confused. There seems to be some conceptual tension between what I'm hearing here. You seem to be arguing for some pretty strong international institutions to levy punishment on war criminals and genocide, which I don't oppose. Yet at the same time, it seems that a robust understanding of national sovereignty is your last line of defense against a lot of the abuses that you talk about in the Lawfare project. And I'm wondering how you navigate that straight so you don't end up having a Spanish judge indicting Augusto Pinochet for crimes against Spaniards that occurred in the 70s in Chile in 2000 whatever, therefore upsetting the political compromise upon which the modern Chile is built.
Well, I think that the principle of complementarity sort of preliminarily answers that concern. I mean, what you have asked about is basically the #1 philosophical problem in international law that we have not solved yet, and we've attempted to with the principle of complementarity. And that's that an international court cannot exercise jurisdiction unless it's a jurisdiction of the last resort, unless the state sovereign in which the crime has committed, or the state with some sort of connection to the crime or the perpetrator or the victim to allow it to exercise jurisdiction, has proven completely incapable in doing that. Therefore, there is a need for an international tribunal to step in. That's sort of the philosophy where it's evolved at this point. I can let you address that.
No, that's absolutely right. And one of the things we always argued is what she just said was these international forums should be a court of last resort. So you want to encourage the domestic processes for the reasons we talked about before: ownership, rule of law, the growth of the rule of law. But there are times where all that fails, and you need to be at in the international space. And we also need to recognize that domestic processes may not have the result that what some people would want. And that doesn't mean that it was wrong. You know, and one of the problems we have with the International Criminal Court is the way it is currently set up is you could have a prosecution here in the United States for whatever, war crimes, whatever it may be, and if the jury, for example, let's say they acquitted the person, the International Criminal Court would still have the opportunity to say, you know what, that wasn't good enough, we're going to take that case and prosecute that case. So the tension is there, it's not refined, and it needs to be addressed, but we need to actually look back, try to start from the domestic view and then work up.
And just one last thing, another point of Angel is that what we're trying to do is encourage attorneys to write about these subjects and come to conclusions that are in the best interests of liberal democracy, because right now, the issue of the status of international law and universal jurisdiction is being written about by people who don't have the rule of law in mind. And what we need to do is counter this and create a jurisprudence that people can debate, that can be used in courts of law to shape their opinions. So I would ask you, I would invite you to help us ponder these issues and to write in legal journals about them.
One of the problems in this regard, that getting back to the OIC, under Sharia law, they don't recognize Western jurisprudence themselves. That's a formal position under Sharia law, as I recall. And it's even more complicated because of the concept of taqiyya, as I recall, that it is an obligation for them, if they're defending their faith, to lie and to distort and deceive and be deceptive. So,
Well, our mission statement is sort of narrowed to examining lawfare within Western judicial systems for that particular purpose. It's not really our mission to go into Islamist states or theocratic regimes and force change upon them. What we're concerned right now is safeguarding the sanctity of the systems that we have set up and make sure that they don't get violated by those concepts. And then once we've done that, then perhaps we can go on the offense, as you suggest. So if that's it, thank you very much.
Join me in thanking Thanks so much for coming out this afternoon. I hope this discussion has spurred some serious thought on your part, and that you'll follow up on the discussion and give it some more thought, and perhaps some of you get involved.
Thank you for coming.